something in her tape-recorded interview that they showed her, and it was something she didn't remember saying. She had no memory of it. That's the way they did it.
Oh, okay. Well, I'm not.
And they said it had to do with her saying that she didn't remember Nicole when they interviewed her in 2006. She said Nicole didn't call or she didn't remember Nicole calling or something like that on that day.
Well, she says right here, you don't recall receiving any phone call. But that's not different than what the other one says. Is that what she testified to?
I don't know exactly. Well, check.
Here's what I wrote. Nicole called into the gym for David Pietz. She called off. Didn't know if she got a call from Pietz.
It's great. Kristen, may I get one thing? I'm sorry, 1 minute to bring the judge.
So here's the put Anderson on it. I guess.
Yes, I will. Thanks.
LS. Talk about himself. Detailed self.
Great voices of all time. Young people from money know who it is.
Yeah.
Pillars of Johnson Road.
We're good, Sharon. Thank you.
You know they played this concert really time. Black and white photos. All these famous all kinds of superstars playing these bands. And this is not too long, not long not many people say great.
Yeah.
He was one of my favorites. Yeah, they're still out there. All those groups from the 70s who were playing the casino circuit. They'll pay you. That's a tough business. Get it while you can, because you'll be forgotten.
Please rise for the beginning of the session.
You may be seated.
Your Honor, I believe Detective Anderson is going to be called back today to testify about something, and I'm not sure it's admissible. It has to do with Ms. Knutson's testimony yesterday. I'd like maybe if the state could make an offer, and then I could, once they do that, we'll know I got it straight, because I'm a little confused, and then I can make my motion.
Your Honor, we're going to recall Detective Anderson because he is the detective who talked to Christina Knudsen on the telephone on February 13th of 2006, which is the testimony you recall at the end of yesterday. She apparently has no recollection of. I tried to refresh her memory, and she indicated, I don't have any memory of this call. In light of that, we're going to provide some additional foundation from Detective Anderson, in addition to foundation that was already provided by Ms. Knudsen, and offer that one sentence, the sentence that Christina Knudsen did not recall getting a phone, does not remember getting a phone call from Nicole Pietz on January 28th of 2006 as a recorded recollection under ER 803A5.
Wait a minute.
The criteria.
Back up a second. Ms. Knudsen said, I don't remember a phone call.
Right.
So what supposedly is Detective Anderson going to say?
Well, let me first start with the foundation that needs to be laid for the recorded recollection, some of
Well, I
which
understand what the foundation is,
Okay.
but we'll back up. What is Detective Anderson
He's
going
going to get up, and I believe he needs to lay some additional foundation and say, I talked to her on this date, I asked her questions, I wrote down what she said, I accurately recorded it in my report, this is accurate, and then we're going to offer it, that statement as a recorded recollection that can be read to the jury, just that
What's the
statement.
statement?
What I just said. I believe it's, I'll read you the exact quote, but Christina Knudsen does not remember getting a call from Nicole Pietz on January 28th, 2006. It's, I think we have the exhibit that has it in there. It's the third sentence in his entry. Christina said she doesn't remember Nicole calling Martin at work on January 28th. And we want to offer this as substantive evidence because that was only 2 weeks after the supposed phone call would have happened. The statement that she testified to yesterday about that statement was 2 months later. So in order to make clear that...
And she's saying today she doesn't remember.
Correct. She's saying she doesn't remember anything about this conversation with the detective. So that has to be true for us to offer recorded recollection. So we are now offering it because...
Slow down a second. Her testimony yesterday, I think, was, I don't remember a phone call from Nicole Pietz on that date.
That's
Her
correct.
statement to the detective was, I don't remember a phone call from Nicole Pietz. Is that right?
This testimony yesterday was what I told police in April was I don't recall a phone call. This is a statement she made in February 13th, which is a
Said
big
the same
difference.
thing.
But it's a big difference because it's only 2 weeks after, and I believe in closing argument, defense is going to argue, how can she know 2 months whether she really got a phone call from Nicole or not? In light of how they crossed, it's pretty clear they want to argue, she got calls from Nicole all the time, how could she possibly remember? We have a right to offer as substantive evidence that only 2 weeks after the alleged phone call, she clearly says, I didn't get a phone call.
I don't remember getting a phone call.
No, she's right. Well, the jury is entitled to interpret it however they wish. We are only allowed to read the exact recording, and it is not allowed to go back to them in written form, but it is allowed to be read to them. And we are allowed to get substantive evidence in from that date. The purpose of recorded recollections is when witnesses literally don't remember, but it was recorded at the time by someone who accurately recorded it, it can be read in. Now, Ms. Knudsen did testify that she doesn't remember now, but she knows what she told the police back then was truthful. That, we believe, establishes some of the foundation. And I'll pull up my notes from last night when we pulled the cases on it. It has to pertain to a matter about which the witness once had knowledge, which she acknowledged yesterday. They have to have insufficient recollection now to provide truthful and accurate testimony. She did. She does not remember that phone call in February. The record was made or adopted while it was fresh in her memory. Again, she testified yesterday that she knew it then but doesn't remember it now. Anderson will establish that it was only 2 weeks after the fact that she talked to him on the phone. And we have to establish that it reflects her prior knowledge accurately. She said she told police the truth back then, even though she doesn't remember now. Detective Anderson will establish that he accurately wrote down and put in follow-up what she said, and then we'll be offering that one sentence as a recorded recollection. The case law that we researched last night shows that many different kinds of notes, statements, interviews can be recorded recollections. Doesn't have to be an actual recording, and we believe that that foundation is met once Detective Anderson testifies that he accurately recorded it and wrote it down.
There's a couple problems with this, Your Honor. First, I think that this is cumulative. I don't see their difference that they're talking about. But secondly, it doesn't meet the requirements of recorded recollection.
Stop right there first. Cumulative.
Well, she's...
Her concern is that as I hear it, is it leaves open the argument that she probably did recall a phone, I'm sorry, there probably was a phone call from Nicole Pietz, but given the lapse of 6 years or 8 years, she simply doesn't remember.
Okay, well, look,
Her argument is that might be true, but wouldn't she have remembered it if it was only 2 or 3 weeks later?
okay, well, let me go on to my second argument, which I think,
Okay, so is that cumulative, or are you going to, I mean, is that an argument defense would make, that there probably was a recall from Nicole, but this is like, 7 years after the fact. How would she possibly remember that?
well, I think we're entitled to draw those inferences, Your Honor.
All right, well, if you're entitled to draw that inference, then it's not cumulative if she says 2 weeks later she also didn't remember it.
Let me go on to my second argument.
So that takes care of that one, I think.
Your Honor, we're not waiving that argument, but let me go on to my second one. The rule is very strict, and it says, and the part that the state cannot satisfy is, the statement has to be shown to have been made or adopted by the witness when the matter was fresh in the witness's memory and to reflect that knowledge correctly. So somebody can't get up there and just say, otherwise, we'd never have the hearsay exception or the confrontation exception. So a witness 7 years later, where we are right now, can't get up and say, well, I don't have any idea what I said to the detective back in 2006, in February 2006. There was a recorded statement that you've shown to me, and I can look at that one in April. But going back to February 2006, I don't remember what I said, but of course I told the truth. That's not enough. It had to have been either at least my memory of recorded recollections, and it wasn't until I came into court that the state gave me that theory, so I'm looking at Tegland here.
Well, counsel, this is the first I've heard that they wanted to offer it either. We're talking about 803A5.
Yes. And in other words, any witness can say, well, of course I told the police the truth back in some year, and the state can't say, well, that's an adoption. It has to be adopted by, it has to either be made by the witness at the time or adopted by the witness while the witness's recollection was fresh. So in other words, if this was shown to her, say in 2007, and she said, yes, I do remember saying that, yes, I adopt it. But you can't go back and just say, well, geez, I'm sure I told the police the truth back then, therefore everything I said back then comes in as a past recollection recorded, because of course this is not an exception to the hearsay rule. This is not hearsay. It comes in as evidence, as substantive evidence. It can be read to the jury.
It's not an exception to hearsay rule.
It's the following are not excluded by the hearsay rule. I don't think it's
that doesn't mean it's not hearsay. It just says it's not excluded by the hearsay.
Well, I thought that...
Look at evidence rule 801.
I thought that there are things that are not hearsay.
There are, under 801. A statement is not hearsay if. Under 801, it defines what is not hearsay. 803 says it's hearsay, but it's an exception.
Okay, well, then I stand corrected, Your Honor. But either way, it doesn't come in, because there's unless there's evidence that sometime while this was fresh in her mind, the detective called her back up on the phone and said, look, do you remember telling me this? Yes, I do remember telling you this. And that never happened. She has no memory of it now. So my point that I come back to is, if this is a proper exception, then nothing is hearsay that people told the police in the past, as long as they're willing to say years later when they have no memory, well, I'm sure I told them the truth.
Well, let me suggest, I'm not sure I agree completely with what you say, because it says shown to have been made by or adopted by. So if you give a recorded statement to the police, and then years later you say, I don't remember the events, you show them the recorded statement and they say, that does not refresh my memory. And then you follow up with, at the time you made it, were you trying to tell the truth? Yes. That, in fact, does comply with the rule. You don't have to show them the statement that they've made afterwards and say, okay, is this your statement? You adopting it now. If they make the statement at the time, and they say that the time they made the statement, I was telling the truth, and now I don't remember what I said, as opposed to my memory being refreshed, then you fall under 803. The problem usually is that most lawyers I see tend to mix and match 803 and 612. 612 being refreshing, and they simply show it to them, and they say, oh yeah, my memory's refreshed now. When it usually isn't, they simply read what it says. In this case, the witness is saying, no, it's not refreshed. And then if it's not refreshed, then you kick over to 803 and see if 803 is satisfied. But I will tell you that I've not yet run into a situation where they're not using a recorded statement or a statement that they signed. They're simply using statements that they made at the time and that the police recorded that they said. I've not seen that case. She says there are such cases. I've never read one.
Your Honor, I don't think it should make any difference. I mean, I see that there is a difference with a recorded statement. Nevertheless, the purpose of this rule is to show that there's some reliability to the statement. In this case, I recall Ms. Knutson testifying that she didn't even remember talking to the police back in 2006. So I don't see how she can go back and say, well, geez, that was correct what I told them then, because otherwise, a ruling like this, I mean, assuming that I'm wrong on this and the state is right, there's no longer any hearsay or confrontation exception if a witness is put in the position saying, well, effectively, would you have lied to the police back then? No, I wouldn't have lied to the police. So that means everything comes in. And besides hearsay, Your Honor, I would say it violates confrontation. I can't confront that witness on that statement because it can't be cross-examined about. I would ask the court to exclude it.
First of all, counsel's incorrect. A witness doesn't have to say, oh yeah, here's my statement, I adopted it. They have to say that they gave something at the time and they were truthful at the time, which she has done. There is no case.
Actually, did she say that she remembered giving the statement at all?
Earlier on in her testimony, when she was asked, she said, yes, I remember talking to police. I don't have memory now of things, but whatever I told them was accurate. That was at the very beginning of her testimony before she testified about her April statement. So she said that. There's no case out there that says what counsel is arguing, and I would direct the court's attention. There are cases out there
Counsel,
that don't
just saying
involve...
there are cases out there is not very helpful.
I was just about to let you know, Your Honor,
Thank
there are
you.
cases involving...
Give me the case.
Here's a case that involves a police
No,
officer...
the cases, counsel, the cases are over on the shelves over there.
Okay.
If you got a case you want me to rely on, I direct you.
This is an
Excuse
example.
me. I direct you. Oh, you've got the case in hand.
This is
Okay,
an
then-
example, State
All
v.
right.
Can I have a copy, counsel?
I don't have it, but I'll read it into the record, and you can grab the book.
All right, this is
24.
State versus Madeira, 24 Washington Ave, 354. Would you provide that?
And let me just indicate, Your Honor, before I read that one, I provide that because that's an example of someone testifying from a report as opposed to, for example, a transcribed statement, as Your Honor was wondering about. Your Honor is correct. A lot of cases involve actual statements. The other case I would direct the court's attention to, and I can hand up, is State versus Alvarado, which is 89 Washington Ave, 543.
You're going to have to slow down a second. I'm still on Madeira. And Mr. Allen, you got it?
I have material, Your Honor, and this is the site on the other case.
24 Washington Ave, 354. Give
That's
me
the
a
one I
second.
have. Is there a second case or no?
She did have a second case, which is Alvarado, 89 Washington Ave, 543.
Your Honor, I'd ask in the
Counsel,
future.
would somebody, I know, you're going to say in the future, don't give us this at the very last minute?
No, I was going to say have the courtesy of making an extra copy for opposing counsel.
All right. Well, you've got a copy of the book. All right, I would tell you, counsel, that in terms of the analysis in this case, I think the Alvarado opinion is more helpful than the Madeira opinion. And I would refer to, and I'm sorry, Mr. Allen, I can't help you on the page site because I'm looking at a Westlaw pagination rather than in the book itself. But what it appears to be is the second to the last page. And in the Westlaw, it's headnote 6 and 7. Does that match up with yours? It doesn't work in the your
No,
book?
but I believe there should be some bold numbers that would reflect the Washington.
I don't know what's in your bold numbers. It's about a page back in the opinion.
What's the start of the paragraph?
We agree with the Porter's court's observation. And it reads as follows. We agree with the Porter Court's observation that the rule prescribes no particular method of establishing accuracy. The issue must be resolved on a case-by-case basis. We hold the requirement that a recorded recollection accurately reflects the witness's knowledge may be satisfied without the witness's direct averment of accuracy at trial. The court must examine the totality of the circumstances, including 1, whether witness disavows accuracy, 2, whether the witness averred accuracy at the time of making the statement, 3, whether the recording process is reliable, and 4, whether other indicia of reliability establish the trustworthiness of the statement. So it leaves us really to the discretion of the trial court in a lot of ways. And what I note here is that she was not at the time averring some detailed memory. She was actually saying, I have no memory. Under those circumstances, I don't think it would be fair for the defense to argue to the jury, well, she has no memory now, but she certainly would have had a memory if we were closer to the day in question. Her statement of lack of memory today is not very helpful because she probably remembered Nicole calling if they'd asked her the question a lot longer ago. But they did ask the question, and at that time, she also had no memory. So I think under all of the circumstances, it satisfies the rule.
Your Honor, may I just make a bit of a record here?
You sure may.
I think the difference here is that Ms. Knutson said, at least our notes indicate, that she didn't even remember talking to the police. So her saying that something was accurate in the past is not specific.
She did remember talking to the police. She didn't remember the date she talked to the police.
Right, and we know she talked to the police later on. So we don't know what she's referring to because she apparently had no memory of talking to the police. It wasn't like, well, you talked to the police soon after, didn't you? She wasn't asked that. She was asked, did you tell Detective Anderson, or I suppose that was the question. That's the first thing. The second thing is that I believe that this violates the Confrontation Clause because even though I had a chance to cross-examine the witness, there's nothing I can do on this. This is an unsworn statement given at an earlier time. I believe it could...
Counsel, I just spilled my tea. I apologize. Give me a second.
This was recorded, wasn't it?
Did you get that recorded for national TV?
No, this is the part they read.
The part where you say, you know, he needs to retire. Not you guys.
Well, I see in Alvarado, again, this is something that was just thrown at us this morning. On the top of, at least in the edition I have, 552,
That doesn't help me, counsel.
I realize it doesn't, but the court says that there's some issues, whether the witness disavows accuracy, whether the witness averred accuracy, at the time of making the statement, whether the recording
Okay, that's
process.
the same thing I just read.
Yeah, okay, so there was no averment at the time she made the statement that it was accurate. The detective has some notes down, that's all. And it's not like he said, well, I read this back to her over the phone and asked her if everything was correct. That's usually the way that it's done. I don't think 6 years later or 7 years later you can just ask a generic question, was everything you said accurate back then? And we're not necessarily saying she's lying. I mean, this could just be bad memory, or the detective got it wrong, because there have been parts in the case where people have denied that they have said what the detective says. Whether the recording process is reliable, and the court indicated that typically these come in with recorded statements, so we know they're reliable. Certainly Detective Anderson is going to say they're reliable. He's got pride in production of a report, but that doesn't say whether they're reliable. And then fourth, whether other indicia of reliability establish the trustworthiness of the statement. I don't think we have that at this point. Because there's no evidence that says firmly that Ms. Pietz was deceased at 11:50 a.m. on January 28th when this call was made. So I don't think we have those other conditions of reliability. But finally, and I just come back to this, that if what the court is saying is the law, then any statement made to the police, as long as the maker of the statement, even if they don't remember making it, or even talking to the police afterwards, says, well, it was accurate what I said to the police. I don't lie. That's not exactly what she said, but that's all they have to say. And then all the statements come in. I don't believe that's the law, and I don't believe that should come in that way, and I stand on my objections, Your Honor.
Your Honor, let me just note for the record that the other indicia of reliability is, she said it again 2 months later. I mean, I think that can be considered by this court as indicia of reliability.
Well, the question, the issue here is, does she now have a memory of having spoken to Nicole on that day? She says she doesn't. Did she have a memory in the past? She, at the time she was first asked, says, I have no memory of it. Later when she asked, she says, I have no memory of it. And I don't think cross-examination would provide much solace. If she had given some detailed description, then you could do something with cross-examination. But she said she had no lack of memory then. She had a lack of memory then. She has a lack of memory today. So I don't see the issue there. I'm going to allow it that her, at no time that she was interviewed, did she have a memory of having talked to Nicole. Does that mean she didn't talk to Nicole? No. She may have forgotten about it even a week or two after the event. But I think the inference is it's less likely she would have forgotten it then than she would have forgotten it today.
Once I've laid the additional foundation, I'm going to ask the detective to read that third sentence, because I believe we're only entitled to read to the jury.
Only entitled to read the sentence under the rule. The document itself does not become an exhibit.
Correct. So that is my intention.
Anything else?
Yes, Your Honor.
Yes, sir.
There is another evidentiary issue.
Yes, sir.
And this is with respect to Detective Mellis, who I understand will be the second witness today. And his expected testimony pertains to a cell tower analysis that he did. And specifically, we are moving to exclude detailed analysis and testimony that Detective Mellis is expected to give regarding his comparison of Mr. Pietz's own cell phone records with respect to the cell towers that his phone calls connected to, and comparing those to his own work hours at the 24-hour fitness during the month of January 2006.
Back that up. But my understanding is that the real issue here is that the phone call at 11:50. And whether or not that call was on Nicole's phone, I understand. The question is, who was the person that was dialing her phone?
And that is the issue. We agree with Your Honor on that.
And whether or not, if Nicole indeed was deceased at that time, then the inference is perhaps her husband was dialing that phone. If she was not deceased at that time and was making the call, your argument would be if she wasn't deceased and had already left the house, then he would not have been the one who committed the homicide.
Correct. And I think Your Honor has accurately identified the issue here. What I'm referring to is Detective Mellis has written maybe a 25-page report, a very detailed report, in which he analyzes Mr. Pietz's phone calls throughout the preceding month, January 2006, before Ms. Pietz disappeared and then was later found. And essentially his conclusions are that almost all of the time when he makes a phone call when he's at work, he connects to this particular tower and sector that the phone call from Ms. Pietz's phone connected to. And so it's a very detailed, very kind of complicated analysis that he's done, or it sounds very complicated. We're moving to exclude.
Let me stop you right there. So his assertion is because in the past, all the phone calls from the gym had successfully gotten to that tower, then it's likely that the towers accurately recorded where the phone call was coming from at 11:50, or that you can draw the conclusion that it's coming from the same place.
Right. That's what we expect the testimony to be, and what ultimately the argument will be concerning this.
May I just indicate what he's actually going to say? He's offering no opinion or assertion. He went through the records that are already in evidence that show all the cell tower locations and the addresses, and he went through Mr. Pietz's cell phone records, and he added up how many calls Mr. Pietz made every day during the hours he was at work. The hours
Presumably
were
calls made from the gym.
Well, that's an argument he
That's
can't
the
say.
evidence.
All he can say is
That's
Mr.
your
Pietz.
evidence.
Yes, all he will be saying into the jury is the work hours have been stipulated to. Mr. Pietz, let's give an example. Mr. Pietz clocked in at work at 9 o'clock on a particular
I
day.
didn't read that stipulation yesterday.
We're going to ask you to do that as soon as Detective Anderson is done. And I'm glad you reminded me, because I was going to ask if you had it. Thank you.
I apologize.
No, it's okay. It was our fault. We didn't ask. We'll ask after Detective
Not
Anderson.
working very well.
So, Your Honor, an example is that he will say on, whatever, January 12th, Mr. Pietz clocked in at 9, he clocked out for lunch at noon, he clocked back in at 1, he clocked out for the day at 5. He will then say, I figured out from the phone records, he made 10 calls during that 9 to 5 hours. Here are the towers they hit off of. He's adding them up. And he will just give numbers to the jury. Of the 63 phone calls that went to and from Mr. Pietz's cell phone during his work hours, 54 of them hit off that same cell tower that Nicole Pietz's call hit off of. That's not opinion evidence. That's simply him going through and doing the work and adding up. The evidence is already in here with Mr. Boyle as to the tower addresses, as to all the phone records that contain the tower information. He is doing nothing that's expert. He has simply done a job that we asked him to do, which is figure out whether calls that would have been placed from that gym hit off that same tower. That's it. He's not offering an opinion. He's simply testifying to things that are in evidence. So I believe it's perfectly admissible.
And, Your Honor, our position is that if the records are in evidence, that this would be, I guess, an inappropriate summary witness or summary testimony. The employment records are not so voluminous that we need someone to summarize them for
Let me
us, nor his
suggest,
phone
Counsel,
records.
if the records were not in evidence, then it would be inappropriate for him to do it. It would be excluded under ER 1002, I think.
1006, I think, is the summary rule.
No, it's not a summary rule. It's a discussion to contents.
Okay.
It's the incarnation of the best evidence rule. You may not discuss the contents of a writing without the writing. And I don't know if it's 1002. It's the whole 1000 series is the rules version of the best evidence rule. So if the evidence is not in, the documents are not in, he would not be able to do what they're proposing to do. But once the evidence is in, a witness may testify about the evidence. He may not usurp the function of the jury and decide what that evidence means. But any witness may certainly go through the evidence that's admitted and count up things in the evidence. There's no rule against that. That's the reason you admit evidence, and that's the reason you have detectives, is they gather the evidence, and then once they've gathered it, they can compile it for the jury. That is, in most cases, that is usually what detectives in fact do, because they're not, most times detectives do not have first-hand knowledge of anything. They just collect information. That's what he did here, and there's nothing in the rules that says he can't go through it and say to the jury, I've gone through it, I counted, I find 57 versions. You can go through it and say, well, you missed this one, or this one is inaccurate, or you counted wrong. You can do that. But there's nothing that prevents the witness from going through an exhibit and pointing out what they think they see in an exhibit.
I guess the only other issue I would raise is that I don't believe that at this point we have evidence of the addresses of these other cell towers.
I thought that's what we had yesterday.
Or was that Mr. Boyle?
Wasn't that the big board that had the list of the towers and the addresses?
Yeah, it's Exhibit 74.
Okay, I stand corrected then.
Now, I don't think Exhibit 74 was
It's
admitted for all purposes. It was illustrative.
That's correct, Your Honor.
But the fact it's illustrative, he could still use it.
Your Honor, the only other issue, which I think we can take up later, because I don't think the witness is going to be testifying until later, it has to do with witness Andrea Roy. She's one of the 404B witnesses.
Would you give me a second? Okay, go ahead.
And it has to do with the extent of her allowable testimony as
What
relates.
I'm reading was in their brief was that she met the defendant in 2005, 6 or 7 months before Nicole disappeared. Defendant expressed romantic interest in her, invited her to coffee. Royce declined.
And I believe the court had made some rulings on that, but I'm just saying, before she goes on, we need to have a hearing on it, and I believe that's going to be this afternoon. Is that correct?
That's correct. I'm happy to take it up at 1:30. She won't testify till this afternoon, so if we'd rather defer that, that's
Is that
fine.
the substance of what her testimony will be?
Yeah, we have one issue we need to raise with the court regarding that, but yes, I told counsel that that is the substance of her testimony. So,
And I believe the court has excluded part of that already, but I'd rather take it up later, Your Honor,
Well,
after I...
actually, what I excluded, there was something else that said 2 months after Nicole's death, they began a dating relationship. I scratched that out and effectively said, I think I'm excluding that because I think it's just the probative value is outweighed by its unfair prejudice that once there's a sufficient period of time, everybody recognizes you got to get on with your life.
Right.
But
And the state wants to bring in something now, so we can argue it now or later.
well, we can do it later. We've had the jury waiting long enough.
I'd rather do it later.
And just so the court knows, counsel's correct, I want to revisit that part you excluded, and I'll let the court know why.
Oh, you want that even though I said that's probably staying out? You want it
Yeah,
back
we have
in?
some other information to provide the court, so I'll address it in the afternoon, but just so you know that we are going to be addressing something related to that.
Right.
But yes, she's not till the afternoon.
All right, can we bring the jury in now?
Yes.
Terry? Well, at least I spill my tea without the whole jury watching. Now, the cameraman promises that wasn't on national TV when I spilled my tea. That would be my last act before I retire into the netherworld.
Your Honor, I thought you did that with a great deal of,
Panache.
well, either way.
You can pronounce it both ways?
Yes, you can.
Can you? Ask him, he's the expert. Panache or panache?
I've only heard
He'll look it up and he'll let us know. I thought I just did it pretty clumsy, actually. Maybe that's what Pinoche needs. Please be seated and call your next witness.
Your Honor, the state called Detective Mike Millis.
Good morning. You're already en route. Morning. And that will stick for the whole trial.
Okay.
Can you just, for the record, state your name again, if you would?
Mike Mellis.
Detective Mellis, you testified yesterday regarding some video evidence, and I want to ask you some questions today about some cell phone evidence in this case.
Yes.
First, I want to ask if you have any specialized or particularized training in the area of cell phones or cellular technology.
Well, I guess it starts like video with an interest in the subject as it relates to my job. We obviously get a lot of cell phone data in our jobs, and we've got to figure out what to do with that data, how to show it to people. Much like video, how can we display the data correctly? My interest in the subject started, I guess, in my first detective assignments in around 2000, when I really started to understand, as we all were, how cell phones were affecting our lives and how we were keeping them with us and using them all the time. I didn't obtain some formal training on the subject of cell phone technology and investigations until 2009, where it started with really just a 2-day course. I believe it was entitled Cell Phone Technology and Criminal Investigations. And although I knew this leading up to that class, I was aware that cell towers or cell sites could be used to, generally speaking, locate the area where a phone was when a call was made, and sometimes more importantly, where a phone wasn't when a call was made. I didn't really understand as many details of the technology as I wanted to, and this class gave me the first real insight as to the whole makeup of a cellular network to begin with.
And
then
I'm sorry, that was the 2009 2-day course?
Yes.
Okay, so go ahead.
And then that, the makeup of the network leads to the makeup of the actual cell site itself, which a lot of people call a cell tower, but I prefer this, the term cell site, because it more accurately describes what it is, a series of antenna arrays facing in different directions. And so that was really my first understanding of how I could use this technology. And then it comes in kind of back to the video where, well, we get all these records, either phone called CDRs, call detail records, really what our phones were doing, who we were calling, and who was calling us, and how long, and these records would often show us what tower or sector within a tower was being used to connect that call. Well, what do we do with all this data? It's always coming in the form of an Excel spreadsheet, of sometimes thousands of lines or columns. And then on top of the call detail records, we're also often given a list from the phone company of every single tower, either in the nation or specifically in a state, Washington, or sometimes specifically just in a switch area, a group of maybe 50 or 100 towers, or whatever the number is that serves that switch. But that can still be hundreds or thousands of columns or rows across, and it's all just in raw data, numbers. And so the challenge among law enforcement has always been, how are we supposed to represent this data in a meaningful way to fellow detectives, laymen, prosecutors, defense attorneys, everybody who needs to see the data. My other formal training on it was, I guess my first training was September 2009, a 2-day course. My second formal training was from a different training vendor on the same subject, which was in September 2012. But between those times, I really sought to learn the technology myself, read what I could about it, speak to people in the industry when I could, learn everything I could about it, because I wanted to trust the data that came from these cell companies. So I guess that's the basic history, and I've been doing it. I've been making displays, visual displays of the data from cell phone companies for several years now.
So let me ask, in 2012, how long was the training you received then?
That would have been another 2-day course.
And did that training assist you in also learning how to sort of display and present the type of evidence that's involved in cell phone data?
It did. It added to what I'd already learned. A lot of it was repeat. But all these technologies change over time, and so I want to keep going to these classes, even if it's the same sort of topic. I want to see what's changing in the community of the cellular community.
I asked you a similar question yesterday in regards to videotapes or surveillance evidence. Is cell phone evidence and collection of such evidence a part of almost every case you investigate nowadays?
Like the topic of video, almost, well, I've been involved in, to some level or another, of every investigation almost every investigation of a homicide in King County since 2006. I can't think of a single case that didn't involve some aspect of somebody's cell phone, victim, witness, suspect, potential suspects that we looked at. Maybe a few have slipped through without cell phone, but it's a given that we will be dealing with cell phones in any case we deal with.
And you talked about learning how to present the evidence. Is cell phone evidence also important to you during the investigative phase when you're trying to figure out, who committed a crime or what happened?
It's very important. I use the cell phone data to do two important things, really, and they're about equal in my time. It's to rule people in or remain as a suspect, or to rule them out. We investigate bank robberies in my unit also, and quite often I'll use cell phone cell site data to give me a general geographic location of where a cell phone is, and maybe that cell phone is known to be owned by one of our bank robbery suspects in a series of bank robberies. But if his cell phone doesn't seem to match the pattern of bank robberies and has its own pattern at the same time, that's...
Your Honor, I'm going to object. I think you can testify about his experience, but other cases and examples, I think it's getting a little bit far afield.
All right. I think the jury understands. We may proceed.
Detective Mellis,
That's a sane objection.
when you obtain data on cell phones, do you have to get it from the cellular phone company themselves?
Yes.
And how do you usually go about doing that? Is it a search warrant? Is it something else?
It's, in most of our criminal cases, it's a search warrant. Yes.
So when you talk about taking the data and working with the data, you're working with information that's given to you by the phone company themselves.
Yes.
In this particular case, the Nicole Pietz homicide, were there cell phone records that were received and were relevant to the investigation in this case?
Yes.
And did you review and analyze the phone records received in this case?
I did.
I'm going to show you what's been previously admitted as State's Exhibit 69. Take a moment to look through these and let me know if you're familiar with these. For illustrative purposes, State's Exhibit 70 that reflects some phone numbers here. Are these the phone numbers that are what those records are about?
Yes, they are.
And are you familiar through the investigation that Nicole Pietz had what was called a BlackBerry cell phone?
Yes, I did.
And which number is the BlackBerry?
The BlackBerry is the 206-388-9615 number.
in those records that you have before you, we had some testimony yesterday about the type of records they are. I want to ask you about the format that these records came in.
Yes.
Did you get two types of formats when you received these records?
We did.
And can you describe what that means?
When we receive a response from a cellular company, they usually come in one of the three formats, either an Excel spreadsheet or a PDF file or a text document. The general difference is with a Excel spreadsheet or a text document, you can work with the data quite readily, change columns and organize it how you need. With a PDF document, it's sort of a static document. You can't really, it's not easy to deal with like you can with a spreadsheet. And in this case, the records came in a PDF format and a text format.
Okay, if you could look through that notebook, can you flip to a page that would be what you consider the PDF? Hold that up for the jury. Is it 16, Detective Mellis, is that 69?
6'9".
6'9". And actually, let me show you Exhibit 71, Detective, that was offered
Yes.
yesterday. Is this an example of a PDF format?
That is an enlarged copy of a PDF format that we got from the phone company on this case.
So this is how you get it, this is how it looks?
Yes,
Can you find in there an example of the text
I can.
format that you're referring to?
I just pulled up a random page of the text portion of the folder.
And can you just say again, obviously it looks different, but how is it different?
Well, all the information is the same. There's the same columns and so forth. In a text document, though, I can basically copy and paste them into an Excel spreadsheet that once it's there, we can manipulate the columns, organize them, I guess is a better way of speaking, to better understand them. In that format, it's difficult to read just as a text document, but I can at least turn it into an Excel spreadsheet, which is easy to read.
Counselor, could you turn that?
Yeah, I'm sorry. So if I'm understanding correctly, the text version that you get, you can move around, but the PDF version you can't?
Yes.
Okay. Let me know if you need this. I'll leave this here. Actually, I'm going to give this back to you for my next questions. Were you asked, and did you at some point go through all of those phone records to determine how many calls were exchanged between cell phones that belong to the defendant, Nicole Pietz, and also the 24-hour fitness gym in downtown Seattle?
Yes.
Now let me ask you first, are you familiar with the phone numbers for the 24-hour fitness gym in downtown Seattle?
Yes.
Can you tell us, and actually I'm going to ask you to write on this, the 24-hour fitness gyms, I'll put it on the back of this, phone numbers if you know what they are. Do you have them written down somewhere, or do you have them
I
memorized?
do. I knew we were talking about some numbers and lots of numbers today, so I wrote down some notes of what I thought.
So why don't you first indicate, is there a main number for the 24-hour fitness gym in Seattle?
Yes, the main number is 206-624-0651.
Oh, yeah. It's pointed out to me, counsel, that that's some Scotch tape on it. The clerk tells me that for purposes of the record, the back of that board is not part of the exhibit.
And that's what I just recognized, so I'm actually going to write it on the front. And I had a feeling that's what you're saying, which is what reminded me.
It's illustrative only,
It is illustrative only,
but
so.
the back of it, if it goes in the exhibit room, it will not contain the back,
Yep.
is what he's telling us.
So-
That will disappear from the illustrative exhibit unless you put it in.
Thank you, and that is exactly why I'm moving it to the front. So Detective, I'm sorry, the main line is 206.
624-0651.
Okay. And are there some back lines at 24-hour fitness from which calls can be placed?
There are other lines there, yes.
What are some of the other lines?
In 2006, the lines were 206-447-1253 and 206-447-1254. 447-1298.
Any others that you're aware of?
I don't know if there are others.
These are the ones that you're familiar with? Okay.
Yes.
So when you went through all of the phone records that we just discussed, did you go through and look for all of these now, I guess, 6 phone numbers to figure out communications among them?
Yes.
And did you do that for the time period of when Ms. Pietz first disappeared, January 28th of 2006, up to the point where her body was recovered on February 6th of
Yes.
2006?
Excuse me. Yes.
That's correct. Stacy to the 84.
And Detective Nellis, did you in fact create a chart reflecting the communications among those 5 phone numbers?
Yes.
I'm going to show you State's Exhibit 84. Take a moment to look at that. Let me know if that is the chart that accurately reflects the communications during that time period between those numbers.
It does.
What about Exhibit 84?
Illustrative purposes.
I'm sorry? No, I want it for substantive, Your Honor, under ER 1006 is a summary chart.
Your Honor, we have no objection for illustrative purposes, but for substantive evidence, we have to take it up later.
For right now, I'll call it illustrative, and we'll deal with the rest of it outside the presence of the jury.
So Detective Meltz, I'm going to have you step down just so you can be sure to see. I want you to step to the side over there. So first of all, just to orient us, actually, it looks like, did you start on the 27th of January?
Yes.
Okay. So this chart reflects the 27th through February 6th?
Yes, in relation to those numbers calling back and forth to each other.
Okay. And the different colors refer to which numbers? The different colors, do those refer to different individuals or phone numbers?
It is. Sometimes we use colors just to make the chart a little easier to see. But yes, the name and color represents the different phones being used.
So why don't you go through, starting with the first line, and indicate the first time you found a communication between those numbers on January 27th.
On the 27th,
And Your Honor, I'll just renote my earlier objection on summary evidence and his testimony regarding the analysis of these records.
Objection noted, then read.
on the 27th, which is a Friday afternoon, the first phone call is a phone call from Nicole's phone to the 24-hour fitness business line at 4:22 p.m. and lasts about 4 minutes.
And I should ask, do you know, when it says Nicole's phone, are we dealing on this chart with just her BlackBerry or just her personal? Do you recall whether the phone calls were her BlackBerry or her personal other cell phone?
No, I don't recall. These are combined. This is a combined communication chart.
Okay. So go ahead. So the first call is from Nicole's phone.
It's from Nicole's phone to the 24-hour fitness business line. The second call on the 27th, Friday night, is at 7:47 p.m. This is from one of the 24-hour lines to Nicole's phone.
And I'm sorry, you're missing the last column. Is that indicating how long the call was?
This one is 2 minutes and 55 seconds.
Okay, and the first one was 4 minutes?
Correct.
Go ahead.
Moving down the chart, again, Friday night at 8:39 p.m. The call is from one of the 24-hour fitness lines to one of Nicole's phones. And it lasts, it's recorded in the call detailed records, but duration says 0 seconds. Moving down, Friday night at 8:42 p.m., a few minutes later, call from the 24-hour fitness line to Nicole. It does last a total of 2 minutes and 12 seconds.
Moving to the next one on the 27th, and the last one on the 27th is at 8:59 p.m. from the 24-hour fitness line to Nicole's phone, and it lasts a duration of 9 minutes.
And let me ask you for a moment, you testified yesterday about work records you'd reviewed for the defendant's hours of 24-hour fitness.
Right.
To your knowledge, was the defendant at work during the time these 24-hour fitness calls went back and forth between that phone line and Nicole's phone?
He was scheduled to be at work, and at times we could certainly see him on the video being at work.
So is that the only calls then on January 27th that went between any of those 5 numbers?
That's the limit of the communication between those phones that evening.
And you checked all the records to make sure there weren't any others?
Yes.
So why don't you start on the next date? Is the next date January 28th?
28 is a Saturday. First communication between these devices is from Nicole's phone. I do have to know that's from the BlackBerry, to the 24-hour fitness business line. That occurs Saturday morning at 11:50 a.m. and it has a 21-second duration.
And I'm sorry, when you say business line, do you mean main line or back line?
I mean the main line at 206-624-0651.
Okay. And what is the next communication among phones?
After that, now it's the afternoon of Saturday the 28th. At 1:07 p.m., the defendant's phone calls, by defendant, that's personal cell phone.
And I'm sorry, is that the 369-6034 that you're talking about when
It
you
is.
say defendant?
Yes.
So go ahead.
The 1:07 p.m. call is from the defendant's cell phone to Nicole's phone with a duration of 31 seconds.
Okay. And what's the next communication?
Chronologically moving on, still Saturday afternoon, the 28th, at 4:18 p.m., one of the 24-hour fitness lines calls to Nicole's phone with a duration of 30 seconds, followed approximately 1 hour later at 5:17 p.m. on the 28th, another call from the defendant's cell phone to Nicole's phones. That one lasts for a duration of 42 seconds. Moving chronologically, still Saturday afternoon, the 28th, at 5:50 p.m., defendant's phone calls to Nicole's phone with a duration of 6 seconds. And the last call between these phone numbers in all the CDRs and all the call detail records is on the 28th, 10:15 p.m. from the defendant's cell phone to Nicole's phone with a 6-second duration.
So first let me ask, after the 11:50 a.m. phone call that is placed from Nicole's phone on January 28th, are there any other outgoing phone calls from either of Nicole's phones in any of the records that you reviewed?
No.
After the 10:15 phone call on the 28th from the defendant to Nicole, are there any other phone calls placed by the defendant's phone to either of Nicole's phones after that time?
No. The 10:15 call on the 28th, the 10:15 p.m. call on the 28th is the last communication between these phone numbers at all.
And from
Well,
your...
I should be clear, I'm sorry. The last communication between the defendant and Nicole's phone at all.
Okay.
He may have called work after that, but I didn't chart that. I don't know.
So, and I just to be clear, we're just talking about calls from his number to Nicole's phones?
Yes.
And there aren't any others?
There are none after 10:15 p.m. on the 28th.
And Detective, when you reviewed the phone records, did you see whether there were other numbers calling Nicole's phones after this time period? You said there were none from the defendant, but were there other numbers calling in?
Numerous calls were recorded on her call detail records as incoming for days and days after the 28th.
Thank you. You can resume your seat. Now, did you also review the voicemails received from AT&T Singular that had been left on Nicole Pietz's phones?
I did.
And did you put those to a CD or a format where they can be played?
I did.
Can I have this one?
85. Stacy to the 85.
Detective Mellis, this is State's Exhibit 85. Is this CD Pietz' BlackBerry phone?
Yes, it does.
And can you explain how you, like, what format you put those on there for presentation?
I targeted a couple different formats, but for presentation, I believe I put it in a format that, which it's an audio recording, of course, audio recordings, but we put it in a format that showed on video as the calls go through, cycle through chronologically, so the viewer could watch, see the date and time, and there's an additional, what I call message number, which is a message number assigned to that particular voicemail message. So the viewer could actually see which message relates to which message number.
And on some of these calls that were placed, did the caller themselves identify themselves?
I believe most of them, the callers did identify themselves.
Some of the calls, did the caller themselves even say the time or day that it was when the call was placed?
Yes, they did.
Your Honor, I'm going to offer exhibit.
Any objection to Exhibit 85?
No, Your Honor.
Admitted.
Okay, so Detective Mellis, why don't you step down for a moment, because I'm going to have you tell the jury, we'll pause it between the calls, and you can tell the jury the date and time that this call was left. So can you just explain, is that what all these different files are on the front of this screen?
Yes, just for visual aid, I made a symbol for each file that includes the date, the specific time, and then the message ID number, so you can refer back to the sheets, the information sheet that came with the voicemails and the search manual.
And this first call, before we start playing it, is what date and time is this left?
It was January 28th of 2006 at 10:45 hours, or 10:45 a.m.
Go ahead, Detective Pavlovich.
Hey, Miss Nikki, where are you? Hey, Miss Nikki, where are you? I was hoping you were going to be at the meeting this morning. I thought you were. I checked my messages at home, and you didn't leave one. So I hope everything's okay, and that we see you here, okay? I love you. Bye.
And what's the next call going to be, Detective?
Same day, January 28th, 06 at 12:41 hours, which would be 12:41 p.m. on Saturday the 28th.
Hi, Nikki. It's Ellen. It's about 12:45 on Saturday, and I was trying to get in touch with you to figure out maybe what we'd be interested in for dinner. Anyways, I will hopefully talk to you very, very soon. We're going to head out to the mall. Jason is interested in looking at trendy shoes, so you're welcome to give a call and put in your votes. Anyways, I'll talk to you soon. Bye.
And what date and time is the next call?
Yeah, I have an objection that I'd like to take up outside the presence of the jury.
Jury, please join the jury. Have a seat.
Your Honor, I guess I am asking the court to revisit the admission of all of these voicemail messages. We don't have an objection to them playing David Pietz's voicemail messages, but all of these other messages which are on her answering machine, which go...
Just a second. You want me to revisit the admission? You had no objection.
Understood, Your
So
Honor.
now you're lodging an objection. You're not asking me to revisit the ruling because I didn't make a ruling.
Well, that's true.
I accepted you as having no objection.
Okay. I'm revisiting my position.
Okay. Now you have an objection.
Now I have an objection. We don't have any objection to them playing David Pietz's voicemails. That's an admission of a party opponent. They're entitled to do that. But these other voicemails from other people wondering where she is, worrying about her, and so forth, don't have any relevance to the case. It's not probative of any issue in this case, and we think that the unfair prejudice substantially outweighs any probative value. These messages can only be offered to generate sympathy and an emotional concern in the jury without any substantial probative value or any real probative value at all. It doesn't go to show whether or not David Pietz killed his wife. It just goes to show that there's all these people out there who are worried for her. And we think that it has a substantial emotional component that weighs heavily under ER 403, and so we'd ask the court to exclude all these other calls.
Your Honor, actually, we believe they have a high probative value, and they're not obviously being offered for the truth of the matter. First of all, they corroborate testimony of several individuals who have testified and will about calls they placed to Nicole. And it's the fact these messages were left, not what's said on them, that is important to the state. This is in contrast to the fact that after the 27th, and there will be 3 brief messages from the defendant on her voicemail on Friday the 27th, there was not one message left from him on her phone. So that he leaves 3 brief messages on Friday the 27th in the afternoon. After that, there's not one message on Ms. Pietz's phones from the defendant himself. So that
I thought there was some phone calls on the 28th.
Not between them except for the calls.
27th is Friday.
Correct.
You're saying on the 28th you go through all these and there are no messages left for the defendant?
There's none from the 28th all the way through to her body being found. There's nothing left after the 27th by the defendant. So one of the other reasons we want to offer it is the contrast to him not leaving any and other people leaving them. The third probative value to these messages is the tone and demeanor of these people, the escalating urgency, in contrast to the fact that the defendant, despite what he's trying to say, is leaving no such messages on his wife's phone. We have to play all of them to give the sense of the time period. And the court needs to remember the state's theory is that Ms. Pietz was killed on the evening of the 27th. The state needs to play these messages to show that all these people that she presumably loves and cares about are leaving messages asking her to call. The fact that she never calls them back or returns any calls is highly probative of the fact that she was already dead. The defense is going to present a theory that she wasn't necessarily killed that night in her apartment. So the probative value of these messages...
When you say that night, you mean that night or early morning hours?
Correct.
Not necessarily the 27th.
Their theory is that she left the house the morning of the 28th to head to her meeting, and our theory is she never left the condominium that night or early morning, correct? So there's numerous reasons for relevance and probative value to these messages, and that far outweighs any prejudice. Now, we're happy to play them to the court. There's about 19 minutes of messages. There are not tons of sobbing and screaming. There are some emotion, but we don't believe they're highly prejudicial or unduly prejudicial in relation to their probative value. So we need to offer all of them, in our opinion, and would ask that the court allow all of them.
Your Honor, they don't need to play all of these messages to show that David Pietz didn't leave any voicemails. They have the records showing that he didn't call after a certain time. So they don't need to play all these messages to then say to the jury, well, there are no messages on here from David Pietz. They just put up a chart showing he didn't call. Also, the fact that these folks left messages trying to figure out where she is, they've got the phone records. They know people were calling her. They already have people who testified that she didn't come to the AA meeting, and Ms. Arionis testified that she left her a message wondering why she wasn't at the AA meeting. So they already have evidence that folks were calling her. It's not the fact of the messages that we're concerned about. It's the content of them that have a significant emotional component. And it doesn't have any independent relevance to this case. We're asking the court to exclude it.
Thank you, counsel. It's my understanding that the defense in this case is that Nicole indeed was still alive at some period on Saturday. That you take issue with the fact that she was killed either late Friday night or early Saturday morning, and that she indeed survived and left the home. If that's true, then there's certainly relevance to the fact she continues to receive pleading voicemails from her friends asking her to call them. One inference is if she's getting all these voicemails pleading for her to return the phone call, if she were alive, she would have returned the call, because all her friends are begging her to call. The suggestion I get from it is that she was no longer alive to return those phone calls. I think that in and of itself is sufficient to say it's admissible, regardless of the fact that they were all from other people rather than your client, and there being an inference your client should have been included. But the bigger issue, I think, is was she still alive during the hours on Saturday? And I think these phone messages tend to indicate a fairly strong inference that if she was alive, she certainly wasn't picking up her cell phone. And given the fact that we all know we're tied at the hip to our cell phones these days, that's unlikely. Anything else, counsel?
I guess I would just say that I think the state could bring this in through the records showing that folks left messages and folks called, and it's the content that we're objecting to.
Well, you're not even the content. You're talking about the urgency. The tone of the messages and the urgency, and I think that is what's probative. Were she alive on her phone and heard these messages, I think anyone would reach the conclusion she would have returned some of these messages.
I just want to make it clear that we're not taking the position that she was alive at a particular time, for days or so forth. I mean, we obviously don't know when she died. So.
You assert that she died sometime after she left the house that day.
Yes.
All right. They assert she was already dead. By the time, I assume they assert she was dead by the time she left their condo. Is that fair, counsel?
Yes.
Or maybe shortly thereafter. These messages tend to indicate that she was not alive on Saturday. And part of the state's theory of the case is the reason she was not alive to return those messages is she was already deceased Friday night or Saturday morning. Otherwise, she would have returned these messages. And I think that is probative for the state's theory of the case. And we've already, in fact, heard from these witnesses, many of them, talking about how they made phone calls and called to Nicole repeatedly trying to find out where she was. And that all came in without objection. So this is just the actual phone calls themselves that they've already testified they made and the tone of the phone calls. So I find that they are admissible.
We just asked for a continuing objection.
And you have a continuing objection.
Messages.
Yeah, we can take a morning break.